A judge in Greene County today heard arguments in what's called a post-conviction hearing in the 25-year-old Lillelid family murder case.
Attorneys for Crystal Sturgill, Edward Mullins, and Karen Howell are petitioning for fingerprint analysis based on a law passed last year. That law allows incarcerated people to petition to have fingerprint analysis if there is evidence that has not been analyzed and could make a difference in their conviction or sentence. Karen Howell made a virtual appearance in court today for a post-conviction relief hearing.
Ansley Daniel is outside the Greene County courthouse. Ansley, the judge, any action by way of a ruling?
Josh and Sarah, the judge did not make a decision today, but 4 different attorneys made the argument that their clients really need this analysis because it could potentially lessen their sentences. Now, the district attorney general fought back today, though, saying that they would need to prove their client's innocence and not just the fact that they are not as guilty as the one who pulled the trigger.
They've conceded they don't meet the statutory requirements because they're not here to prove innocence. They're here trying to get a break.
Attorneys for 3 of the 6 people convicted in the Lillelid murders are asking for fingerprint analysis of the gun.
If a fingerprint analysis had been performed on the firearms at issue and had shown conclusively that Karen Howell was not the shooter and that in fact Jason Bryant was the only shooter, is there a reasonable probability that Ms. Howell would not have received the maximum possible sentence of life in prison without the possibility of parole?
Representatives for Karen Howell, Edward Mullins, and Crystal Sturgill say their sentences should be looked at because Jason Bryant is the one who pulled the trigger.
Not testing the weapons was a strategic move by the state. It was not tested, we would contend, because it would have negated or reduced the state's ability to use the death penalty as a threat to enter a plea.
Their attorneys say they aren't trying to prove their client's innocence.
The results could be probative as to who is the shooter, and again, the third pretty much undisputed, I would state, uncomputed test of the prong is the application is not being made to delay justice or to delay execution of sentence.
The district attorney general says that the 3 are just as responsible even though they're not the ones who pulled the trigger.
I just have to prove they were involved in the underlying felonies, that's called felony murder, and that they, under the theory of liability in the criminal law, you can be guilty, just as guilty as the shooter just by participating.
Attorneys for Sturgill, Mullins, and Howell declined to speak with me on camera after today's hearing. Mullins' family was also in the courtroom today. They did not want to speak with us either, but the judge did say that he'll have a decision within the coming days. In Greenville, Ansley Daniel, News Channel 11.